Okay. Good morning. My name is Ivan Mayanja from Uganda. I work with particularly the energy sector, and I've been working in the energy sector for about 7 to 8 years. I've been in the office of the Auditor General for over 12 years, and um, for the course of those 12 years, I've been privileged to work in several sectors: education, local government, health, and now most recently, working in the energy sector for 7 years has made me realize that um, this sector is very pivotal in the socio-economic development of the country, because um, any size, as long as they are commercially viable, of hydrocarbons, and the mining sector has the potential to shape the economic performance of any country. So um, it's important that as auditors we take this sector with the due seriousness that it deserves. That being said, I would like to proceed with my presentation. The presentation is about risk assessment, planning, designing of audit of extractive industries, with execution, reporting, and recommendation. This is quite a big topic. I'll dwell on the areas that I feel might not have been covered and not probably more often spoken about, and leave out the areas that I feel have been covered. Areas such as risk identification, risk assessment. These are things that we have covered in several slides and PowerPoints. Presentation is about the audit process in extractive industries. Quick discussion about the concept of risk, and the EI value chain as adopted from FSI E. The risk identification along that EI value chain, assessment and response, and later on designing an audit and reporting, and the impact of the recommendations from EI reports. We shall pick lessons from a few reports from a few sides. The process is 6 steps and must have already been covered in earlier sessions. Identification and assessment of risks, then identify the audit types after assessing those risks. Include your findings in the EI strategic plan, and then an overall audit plan can be drafted from these. And then we can go ahead and carry out our audit engagements and report, discuss them, and then report our findings to those charged with governance. In our case, it's the Parliament of Uganda. And then implementation of audit recommendations can follow After that, usually usually after we report to Parliament, there is a process that follows that where we engage the clients to find out whether our audit recommendations have been implemented. I will not dwell so much on this, but we all know what the concept of risk is all about, what could go wrong. And if you're faced with a situation, you should be able to ask yourself, what's the probability that this event will affect the objectives or the purpose of the subject matter that you are dealing with. So the concept of risk is very clear, and it's what we use here in guiding the kind of audits that we carry out. What is also a key here is that diagram is that while you are identifying and assessing risks, you are doing so in a particular framework that has been provided by AFROS-IE. This structure helps you kind of have a guided approach on how you can approach a very enormous industry. Extractive industry is a very big area. When we're speaking about extractive industries, if we do not handle it in a chronological, structured manner, you may find that you are all over the place and you may not be able to achieve the objectives of what your audit intended to have. So I think because of the restrictions of resources, the complexity of the subject, we need to have a structure of how we conduct our AI audits. And I know we have probably gone through these 7 steps, but now we're going to go through them while identifying some of the risks. How do we go about this? We have a step-by-step approach at a SI level. That means not at the audit engagement level, because I know there is a similar process at engagement level, but at the SI level, we do obtain an understanding of government activities at each stage. What's the role and purpose of government? Each of the 7 steps that I've showed earlier, we identify the players at each of those stages. Then we go ahead and identify what could go wrong in these entities or institutions carrying out their respective mandates. What could be the possible risks that could go wrong, given an understanding of the environment and the industry from the perspective of your country. We identify those risks. Usually this is done as a collective, not in an isolated room, in a silo. You sit, you engage, you talk to your clients, you review the environment, and then you are able to come up with informed risks that will be able to guide the audits. Then we identify controls, that is regulation, best practice, legislation, policy that affects these risks. Then we do a risk mapping, which is some sort of a basket of risks. and then respond to those risks. So please keep this process in mind while we walk through the slides. Now, beginning with the first stage, which affects all the other stages of the extractive industry value chain, policies and legal framework. Now, in our risk template, we have those three key areas that I mentioned. We identify the government activity. We identify the stakeholders or the parties that are involved in those activities at this stage. And then we identify the risks. And here I have tried to illustrate some of the common risks that come through at each of these stages. So policies and legal framework, we are asking ourselves a number of questions. I've just had an extract, and I will not go through each and every one of them, but it is interesting. Let me pick one. Is the contractual framework concessionary or a production sharing contract? These are some of the aspects that as a government, they make decisions on how they are going to be able to extract the economic rents from these resources. And extraction of economic rents requires construction of a fiscal regime that is both fair to the government and its people, but also to the company that has decided to invest its resources in the country. So you have to pick a choice, and there are a number of advantages and disadvantages of using concessionary fiscal regimes and production sharing contracts, and stuff you could read about. Who has the right to mineral resources is another interesting subject. The rights to mineral resources, for example, in Uganda, belong to the people of Uganda. That's a right that you cannot take away. It's within the Constitution. Ecuador, for example, in its mining law, it states that ownership of mines and deposits by the state, non-renewable natural resources in general, and underground products, minerals, substances whose nature, differs from that of the land, covered by territorial sea waters, are the inalienable property of the state and are not subject to the statutes of limitations or seizures. So Ecuador, as an example there, has defined exactly who owns these mineral resources. So it's important, because then before we go to contracting and licensing, who has the right to contract, who has the right to license an area, that's important, because it has a number of implications. For example, the USA, mineral rights are individual, person to hold. And that's a whole different context altogether. So it's important to identify some of these questions or key activities of government along policies and legal framework. What's their responsibility? Then identifying who exactly is responsible for this, so that you can direct your audit questions to a particular institute or organization or government body. In this case, most cases, the entities that are responsible for policies and legal framework include parliament, subnational governments, judicial arms of government, parastatals, EPAs, civil society. Some of the common risks that we have identified: security of title to mineral resources. That is, if it's not clear, there is a threat of expropriation. What happened in what was that country? Was it Central African Republic, Zambia? Not Zambia, I think Central African Republic. It's one of these Central Africa countries where there was expropriation of mineral rights and an outcry by some of these international companies when the current president made a decision to cancel all previous concessions and contracts. So it's important. Outdated laws is also some of the risks we've identified. The ineffective tax systems. The tax system is unable to collect the required economic rents. It's uncompetitive within the region. So it's important that these laws are kept up to date. After the legislation, we come to government decision to explore and extract. The activity here is to determine the mineral potential of a country, support acquisition, processing, storage, and dissemination of data, conduct environmental impact assessments, among others. Usually, the stakeholders that are involved here, or the organizations, are the Ministry of Energy, the Environmental Protection Agency, private companies, parliament, or what in other countries called the National Assembly. The risks involved are some of the risks involved. Is limited technical capacity to explore mineral potential, lack of offsite data backup systems, speculative prospecting licenses. Acreage in the bank is an issue that is not only common, for example, in Uganda. It's common in most of these entities where there is speculative bidding. The one who bids usually does not have the capacity or ability, technical ability to do any form of exploration, but just wants to have these mineral rights in a briefcase somewhere so they could use them in lobbying for the actual investors. So it's a problem that needs to be investigated, especially where you have a lot of licensed blocks but non-performing mineral rights. So it's a very interesting subject. On the left, I show you a diagram of what government has decided to explore in Uganda and extract. We have gold in the north. We have limestone in the south west, as you can see, the Kilembe mines, the Hima cement, and there is a key there. It may not be clear, but it shows you active exploration licenses, and those where there has been applications. So from this diagram, it appears like the entire country is being mined. But yeah, that's the case, the government decision. But then when you make that decision, now we need to see how these explorations and production of mineral resources are going to potentially improve the livelihood of your citizenry. Which brings us to award of contracts and licenses. Why do we need contracts? Because of the principle of pactum sunt servanda, Latin saying that means agreements must be kept, you see. So even when there is a threat of expropriation, it comes at a cost because there is agreement, pre-stated agreements that have conditions and obligations of both government and the international companies. So once those obligations and promises are breached or abused, there are consequences. We also have contracts because of poor legislation. Remember, our triangle, the contracts sit at the top of the smallest triangle. But if you have very poor legislation, you are bound to have very detailed contracts for each of these players. So we do have contracts because we want to remedy or find a solution to a lack or an absence or an absence of a law or a weakness in the law sometimes, not always, but sometimes. So there are a number of reasons why we have contracts. But most commonly, as the picture you see on your left, is to curb corruption. See if the contract is explicit and it's clear, then corruption is something that you could probably control or mitigate, although not always the case, because there's a saying that one cannot fight corruption but by fighting corruption. So it's quite disturbing animal that at least you can only hope you can cover in some of these contracts. Corruption is seen on so many levels: allocation of licenses, oil trading, in regulation, oil revenues, how they are spent. So it becomes very, very, very tricky. Same thing, which government activities do we expect here? We expect the government to determine the fiscal regime they use. We expect the government to announce licensing rounds. I think in Uganda we had most recent licensing round should be the third or fourth. Granting of exploration, development and production of those licenses. Common risks, need not to emphasize lack of transparency in award of contracts, inadequate expertise in contract negotiations, So we lack the expertise in most cases. But I think in Africa, we have now started coming up. We have a lot of technocrats now. But still, nevertheless, these are countries outside Africa. These are countries who have been participating in the extractive industries for years. So usually you are faced with people on the opposite end of the table who are very, very well versed with what they're talking about. So you will have cases of unfair contract terms. You have to concede certain terms because you need the expertise that they're bringing. So sometimes you find 15 years down the road, because these are long-term contracts, 25-year concessions, 25-year production licenses, becomes along the way, you find that there are some terms that have been, unfairly agreed upon. I give some examples. In Guyana, prior to their renegotiation, their royalty was 2% in the Stabroek block, and it was a recoverable cost, which was a bit unfair, because nowhere in any part of the world will you find a royalty that is a recoverable cost, because royalties must be paid, and once paid shouldn't be, recoverable. But that even being said, the 2% royalty was still on the lower end, as most observers pointed out. Third bullet, let me skip Uganda. Bolivia in 2006 expropriated shares of oil and gas giants to the control of the state. This is what I was talking about, the importance of contracts, because then what they did triggered international arbitration cases. The president then argued that the decision was hinged on protection of national interests, as is always the case. There are other areas in award of contracts that are important because they have implications on the bottom line, or what is the government state take. Issues to do with recoverable costs, the cost recoverable limit, ring fencing, local content, decommissioning, big subjects that cannot be discussed in this session, but you could go back and have a quick look. On the left, I just show what government take could look like, but I'm sure you have discussed this and you're familiar with it. Production, you remove the royalty, and as you can see, that shouldn't be recoverable, which was a bit strange in Guyana's case. Then less cost oil, then you get your profit oil, which includes the contractor's share and the government's share. The contractor's share is still subject to CIT or corporate income tax, and then the government share can be, lifted for marketing elsewhere. So that is it for award of contracts. The next stage of the value chain is monitoring of operations. On the left, I show you mining sites. I think this was dredging in Gambia. And it's important to monitor extractive industry operations, because they have a grave implication on the environment if unmonitored. And we show you some of the activities that government does is responsible for conducting health, social, environment compliance inspections, issuing fines and remediations, certification of decommissioned sites, tracking production volumes, monitoring waste management, cost monitoring. All these activities that can instigate audits. And we've identified some common risks like non-adherence to occupational HSE measures in large and medium scale mines. Usually we have these SCA reports that the companies have made, and there are a lot of promises in these impact assessment reports, and most remedies on how they are on a mid-term, short-term, or long-term strategies on how they are going to mitigate environmental damage are usually not followed. And because these have cost implications, some have very huge capital cost implications. And that affects on the economic viability of a project. So some of these things are ignored along the way, and if not regulated or if not followed, it will have grave implications, short-term and long-term implications on the environment. If a mining site is not restored, if an oil and gas pipe bursts and there's an oil leakage, then you have issues. There is a third bullet there: inadequate inspection of production volumes and tests of value of mineral resources. This is a weakness, especially in the mining sector, where you have porous borders. So there's a lot of smuggling in and out of the country of the minerals or mineral production volumes that are being extracted. So if we do not have systems, if we do not have people, if we don't have the infrastructure that can assist us in executing the role of tracking production volumes, monitoring waste, cost monitoring, certification of decommissioned sites, then we shall have an environmental problem that will cost the nation. And this is where audit comes in. After monitoring, we go to assessment and collection of revenues. So we need now to actually collect our revenues based on the fiscal regime that we have chosen. And on the right, I show you a mapping of revenue streams across the life cycle of a project. And as you can see, this diagram is coming from ICMM, it's International Council on Mining and Metals. It's just illustrating the cycle of government revenues of a typical mining project. And during exploration and feasibility, the red stage, you don't expect much, but a few payments like signature bonuses, acreage rentals, that kind of thing. That's why it's not nil, but it's not much. Planning and construction, that's where the investment wraps up. There's a lot of capital investment going on. And then during operations is where we peak, and it's a longer period than the rest. As you can see, it's 2 to 100 years of a mine. It's a very huge time. It's a very long time. And then there's a decline when the mine closes, and zero when it decommissions. But importantly, as you can see, the period between closure and post-closure is the hugest, because that now exists in perpetuity. And if the mine left behind a huge problem, or if we do not use the revenues to sustainably develop our economy, sustainably extract our natural resources so as to protect our environment, then we shall have existential problem, our problem that exists in perpetuity. So the way we collect our money should be able to collect and plan and manage our resources, should be able to help us in sustainable extraction and development of our mineral potentials. And what I've said actually is on the left-hand side, stating exactly what government responsibility is. Setting rates, collection of tax, collaboration, integration of data systems, reconciliation of revenue data assessed, lifting, which involves lifting, marketing, and collection of revenues from state share of production volumes, involves, in simple language, the selling of government's share of the production of mineral resources. So that share is what is transported and sold maybe to the international market, or processed domestically for domestic use. We do have a different fiscal regime in the context of Uganda for metals, rather for minerals, compared to that of petroleum. We run a production sharing contracts in petroleum, and there's an attempt on the right to show what the different revenues we expect at the different stages, and then on the in the petroleum sector, and then on the left we also have attempted to illustrate the different royalty rates for the different types of minerals. I will not go through this since I already went through government, state, tech. But interestingly, on your right, second last bullet, windfall tax 15% when the international price hits $75 per barrel, is a very interesting tax that has just been introduced in the country, I think a year or two ago. That is to capture any economic rents or crazy jump in the cost of or price of oil per barrel. And that should be able to come through in the current production contracts that are being signed. The common risks in collection. Maybe let me first explain the left-hand diagram. So the bottom line is affected by two things. The bottom line is affected by price and cost. So if we do not control our costs, we're going to affect our margins. If we do not control, we have no control over price, but if we cannot control, if we can't control the price and the price falls, then it will also affect our margins. But let's deal with the things that we can control. Now, let's talk about cost, because cost for cost recovery purposes, especially in production sharing contracts, has a number of risks. And some of the risks are related to what is allowable and what is not allowable. When companies incur costs under a production sharing contract, they expect those costs to be recovered with respect to the cost recovery limit and with respect to the cost or the production sharing contract. And that contract has put parameters, or it has put defined what kind of costs are recoverable or allowed to be recovered, and what kind of costs are outrightly not recoverable. The problem comes when there's some costs that have not been explicitly mentioned in the production sharing contract that will be subject to opinion. And because of that ambiguity, there is always this back and forth. So some of those are the risks when it comes to cost recovery. There is also the risk of tax avoidance practices, transfer pricing, base erosion, profit shifting risks. That is to reduce the bottom line. So if you're well versed with transfer pricing risk or transfer mispricing, then you know what we're talking about. You know how, or what they call the headquarter burden, and how invoices come from overseas, claiming management fees, claiming technical assistance, claiming all these sorts of services and goods that are being sold to affiliate companies that are practicing or engaging in the extractive industries within your countries. But the question is whether those services that are provided are at arm's length principle, abide or comply with the arm's length principle. So some of those risks affect the bottom line, and if not audited, if not monitored at an early stage, they will affect the latter stages of an extractive industry resource. So this you read through: fraud and corruption, out-of-date royalty rates that do not reflect regional rates, poorly designed fiscal regimes, and so forth are some of the risks that can come through when it comes to assessment. Treaty shopping, poorly drafted treaties, overgenerous tax incentives affect collection of revenues. Now, I put something here for you to read and sharpen your auditor's lenses or appetite, because these publications will help you build your professional skepticism when doing an assessment on this stage. There is published OTP report. which talks about many ways to lose $1 billion, how governments fail to secure a fair share of their natural resources. That's a book by Don Hubbard, and a publication rather by Don Hubbard. It summarizes the risk related to revenues and provides examples from all over the world. Very interesting publication. You can go read about that. So that is it on assessment and collection. But after assessment and collection, we expected to do revenue management and allocation. Here, the main principle is that the system for the management and allocation of revenue for minerals or petroleum should be governed by documented rules and procedures to ensure a responsible, accountable, and sustainable use of mineral resources. Yeah. So what do we mean by revenue management and allocation? We are talking about a way government distributes natural resources to different levels of government, institutions, or directly to citizens. But beyond that, also to the different generations of its citizenry. So if, for example, we extracted all our natural resources today and used all the revenues that we have picked from these natural resources, what will happen to our future generation? Or if the generations that came before us did that, what would happen to us? So it's an issue of intergenerational equity, and that principle of fair management, fair allocation, governed by documented rules, procedures, is designed to respect the principle of intergenerational equity. Some of the common risks that we have found here are lack of fiscal rules that govern utilization of extractive industry revenues, subnational governments that do not receive a fair share. Sometimes when they do receive it, it's misused. Risk of exposure and loss of invested funds, public expansion, white elephants, useless infrastructure, or useless expenditure that does not have a return on investment is what we call white elephants. Offshore investment practice in violation of investment guidelines. Yeah, so a number of risks can come through. These are just examples when it comes to management of fiscal revenues from extractive industries. Now, when we talk about revenue management and allocation, there is no way we cannot talk about a sovereign wealth fund. This refers to money that is invested by a country in order to protect it from economic shocks or to save it for future generations. Now, sovereign wealth funds with respect to extractive industries are a subject of very many domestic risks, but also international risks. I think the most, I think and I know that the most ideal sovereign wealth fund is the one of Norway, where we pick most of our lessons. They've been able to do an amazing job with um, the idea of sustainable extraction of extractive industry, sustainable management of extractive industry revenues. So it's a go-to fund when you want to learn a lot of things. Common areas of interest: accuracy and completeness of revenues reported in the fund, transparencies of expenses and fund balance, compliance with transfer provisions. This is with respect to complying with the fiscal rules that are set in place within a country. So it all begins actually with a fiscal rule or a fiscal policy defining the revenue if coming from extractive industry that is available for investment, available for saving, available for budgetary support. And these rules must be respected, audited, reviewed, monitored, and all that kind of thing. Another area of interest: utilization of funds transferred for national budget support. I've already mentioned. Accounting policies and general presentation of financial statements, important. Compliance with investment rules and guidance for offshore assets. So there could be an in-country policy on how exposed you can be as a country on offshore investments, and that can come through in particular investment rules and policies. And when these are not respected, supposing these fund managers are very optimistic or there are risk takers, there is always a risk of abusing these investment rules because the returns have a bearing probably on their bonuses, have a bearing on their performance, and so forth and so forth. Yeah. So there is a good read here, publication by Jody Vittori, Carnegie Endowment of International Peace. What's the risks in sovereign wealth funds? You will have a blast, I promise you. So you can go and read about sovereign wealth funds and knock yourself out. This is a very good book. Lastly, implementation of sustainable policies is also another stage, as you can see on your left, that affects all these other stages. And this one is about having sustainable extraction of your mineral resources. And you should be able to design policies, to design activities, to design agencies, to design rules that are able to ensure that at every stage of the value chain, there is sustainable development. Yeah. Aspects to consider in the policy and legal framework: we have environmental, health and safety regulations, social impact regulations, revenue management regulations. We've discussed fiscal rules, local content policy and legislations, contracts, and so forth. In government activities, we have baseline assessments, verification of license compliance, environmental and social considerations when exploring. In award of contracts, they should be able to incorporate environmental impact assessments in the licensee's requirements, monitoring of operations. These are all just examples. There's a lot that can go on when it comes to sustainable development requirements at every stage. Assessment and collection of revenues, rehabilitation fees, monitoring fees, community development funds, decommissioning funds as a requirement should be For example, decommissioning funds when production. In the Ugandan context, the production sharing contract requires that when production hits a certain percentage, I think it's 50 or 60%, that should trigger a decommissioning fund. In revenue management and allocation, we have managing and allocating revenue to and from community development funds, decommissioning funds, or sovereign wealth funds, etc. and etc. So there is sustainable development at considerations at every stage. Once we are done with that, then we can identifying our risks, then we can do a risk assessment. Now, this exercise of mapping risks is done at site level. We do it to rank them in their order of priority because we do not have all the resources in the world. We have limited resources, so we address risks in the order of their priority. How do we assess them? We look at the likelihood and impact of occurrence of that risk, and then we can be able to rank the risk, whether it's critical or high, as a matter of ranking. We can use this risk chart to do that ranking. Red showing it's hot and should have been done like yesterday. It's very, very, very serious. Its impact is very serious and its likelihood is very, very high. Now, there is a whole exercise on doing a risk assessment, and there are templates that we use. That is one of them. Along the entire value chain, you can like mentioned, have the risks that you've identified. What is motivating those risks? That is a risk factor. Have our likelihood and impact, and then have an overall risk assessment using your chart on whether the risk is red hot or green and does not need any further action. But supposing the risk is red hot, then you will have to come up with an audit topic to address that risk, and then define which kind of audit type you will conduct to address that risk. And then according to your SI, you'll be able to identify which is the responsible unit or responsible resource that is going to conduct this audit, and define the time period. When selecting an audit topic, we consider three things. And I'm sure you're familiar with some of or all of these three aspects. The relevance, which refers to the mandate and materiality of the focus area or audit topic. We do not want to audit things that are not material. Material can be financial materiality, but there is also social materiality. There is political materiality. So some of this should be considered within the context of the country or environment that is predominant at the time. Can you audit a policy? That's a question that is for you to answer. If you can, in your relevant SI, that maybe is not the case in most of our SIs. Do you have the mandate to audit private mining companies? As a supreme audit institution, this is also debatable. depending on the audit topic or audit area that you have chosen. Is this topic still of public interest? Producing a COVID report right now might a bit be outdated. Maybe it's not necessary right now. Maybe it is. I don't know. That's for you to answer. Auditability. Can data be obtained? Yeah, so when coming up with audit topics, we usually discourage topics like corruption because how will you obtain data on corruption? So it's a matter that needs to be considered. Is there a relevant audit criteria? Riots, legislation, policy, regulation, laws that define the criteria that you are going to use. You know, with audit, as auditors, we use a basis of opinion. We usually use a basis of audit opinion, of judgment. So the question is, can you define your basis? If you can, then probably you have a good audit topic. If you can't, then you should consider refining the audit topic into something that can be audited. Is it within your mandate or audit right? I understand in some size there can be a restriction on audit right. So some areas are not audited probably by the SAI, they are audited by the Revenue Authority, or the industry regulator has the mandate to do certain work. That could be a question that you should be able to answer. Do you have the skills or not? That's a simple, quick yes or no. Potential for change. Avoid repetition. Don't want to do the same audits. We have limited resources, remember. Is it likely to result into policy change? And so forth and so forth. Now, the audit type, I will not go through this because it has been covered before. Can be financial audit, performance audit, compliance audit, or any other special audit, which can include an IT audit, forensic audit, an engineering audit, and so forth. This has been covered, so I will not go through that. Now, in designing an audit, you may need, you may not need, but in our case, we do have a dedicated extractive industry unit. It's a multidisciplinary team. It has petroleum economists. It has petroleum environmentalists. It has geologists. It has lawyers. It has, I think, 2 lawyers. It has economists. It has accountants. Yes, and I think a sociologist, and a statistician. Yes. So it must be a multidisciplinary team so that it can bring various perspectives on how to combat an audit risk in an audit topic. So it's important that you have these multifaceted views on how to proceed. An EI strategic plan based off a sectoral mapping that you have just done, which is done continuously, updated as the sector evolves. Then the EI audits could be done in-house or outsourced, depending on the capacity. Remember, asked you when you are developing an audit topic, you ask yourself, do I have the competence to address this risk competently without my work being questioned? So It's important. More directed internal and external collaborations when you have an EI unit, that also helps. In our case, we have had to be engaging with our sister size, Wegay, AfroSci-E, and all these have a great contribution to the work that we actually do. MOUs with other government agencies is also possible, and then continuous training of the multidisciplinary team. So some of the audits, now we are in engagement audits, that the section of engagements of this presentation. Some of the audits that we have done in our Uganda's case, arising from the risks assessed and the audit topics. We've conducted an assessment on licensing and enforcement of standards, that is downstream petroleum operations. We've done an audit on implementation of national content, an area that I've actually rarely spoken about in this session, but is a very, very important area, and huge, big topic that needs to be considered in your various contexts. We've also audited regulation of artisanal mining, audits on the petroleum fund. We've done cost recovery audits, which is a big nightmare, in my own opinion, of the production sharing contracts. That's an area that I mentioned earlier. It's a huge area. And currently we are still doing 2022. You can imagine in 2025, but some audits cannot be rushed, as you can imagine what cost recovery in the petroleum sector could actually mean when you are investing millions of US dollars. We've done compliance audits on assessment, collection, and allocation of reporting on mineral royalties, and the other IT audits on the mining cadastre. In Kenya's case, I have seen that they have audited monitoring also of mining operations of the said Department of Mining. It's important, remember, mining of operations, or rather monitoring of operations. What we mentioned earlier in the stage, to do an audit in this particular area will be a very good service to the country, in your respective countries. Performance audit on the preparedness of the State Department for Petroleum to monitor costs. Interesting audit, and very recent also, 2021. Performance audit on monitoring of artisanal mining of operations by the Ministry of Petroleum, 2022. Tanzania has also done an audit enforcement of environmental control systems in the mining. As you can see, we are all most interested, certainly in sustainable development and extraction and development of our mineral resources. Tanzania has also done an audit report on provision of support to small-scale miners. Now, these are all reports that are accessible on the websites. You can just download them and knock yourself out. They are very, very interesting reports. If you're interested in this sector, you would love them. Some of the findings or the impact of our audit recommendations have been very, very interesting. For example, we had the finding of speculative mineral licensing. Remember, I told you about speculation. And the law was changed to introduce competitive license from brownfield mines, which means now if you do not perform, we do have a situation where your acreage will have to be relinquished and then subject to a competitive licensing round. And that's very, very, very interesting. Inconsistent figures for production between URA and MEMD. We have had a change in law to introduce traceability and certification mechanism, and so forth and so forth. Failure to effectively register and regulate artisanal mining. We now have a new class of mining rights tailored to artisanal and small-scale miners introduced. The artisanal associations created to better regulate the category. And also, I am aware that they are now being registered and licensed, so you cannot just wake up in the morning because there's a gold rush somewhere and you start mining. You now need a license, even if you are an artisanal miner. Yeah. These impacts go on and on. This is something you could read, but if you want a very well-versed write-up, you need to download those reports that I have just mentioned and read through yourself and see some of the findings that come through and recommendations that have been put across to those charged with governance. Mining, second bullet, mining rights issued on land exceeding the prescribed measurement. There has been a change. Mining license should be granted in line with the land and extra acreage must be relinquished. Very interesting findings. So you can go and read those reports. In conclusion, we are saying that the role of the SAI cannot be overemphasized in streamlining operations in the EI. We are also saying that SAIs are encouraged to conduct a risk assessment along the EI value chain. So you can have a structured way of doing this work. This is a very huge sector and it's very complex. So it's important to have a very structured way of carrying out your audits. And we are saying due to limited resources, risks can be prioritized based on a risk mapping to assess the likelihood and impact of the risk. And lastly, we are saying the SAI needs to determine an appropriate risk response in terms of the audit type and the timing of the audit. With that, I want to thank you very much for your attention. And in case there is any clarification or contribution, or you just want to have a chat with me, you can reach me on those contact details. Otherwise, I thank you very much for being patient and listening to me. Ciao, ciao.